Let's set the stage. It's 1783 in America. The Treaty of Paris has just been signed. The war is over. People are celebrating, but a new evil arises. The states start arguing. Traders can't get past state-imposed tariffs and laws. Big states are bullying the little ones, and there's still the national debt. Paying it off is supposed to be the job of Congress. The states won't listen and give money to it. Great Britain will not respect the United States and openly violates the Treaty of Paris by maintaining troops on the Mississippi. In the North, farmers are losing their land because they can't pay taxes. They can't do this because the money they were paid for fighting in the Revolutionary War, the Continental, is worthless. So they rise up in rebellion. It gets so bad that Benjamin Lincoln, the first Secretary of Defense under the Articles of Confederation, has to lead an army to stop it. Founding Father James Madison knows the country must change its government. He invites the states to send delegates to a convention in Philadelphia to amend the Articles of Confederation. He writes to George Washington, who has retired from public service at his home at Mount Vernon. He knows that if George Washington doesn't accept, the states will not send delegates. So George Washington first declines, so Madison bluffs, telling the delegates that Washington will be there, all the while hoping he will be there. He arrives in Philadelphia worried, but George Washington enters public life again and comes to the convention. Once there, Governor Edmund Randolph presents Madison's plan. This is commonly known as the Virginia Plan. This plan is very similar to the Constitution. It had a bicameral, or two-house legislature. Representatives to the lower house would be based on population, and the lower house would elect the upper house. This was not acceptable to the smaller states. They got enough opposition to stop the passage of the Virginia Plan. They came up with the New Jersey Plan, a plan with a unicameral or one-house legislature, with each state getting one vote. The convention became heated with debates over the plans. Roger Sherman, a delegate from Connecticut, presents a plan known as the Connecticut Compromise. It proposes a bicameral legislature that has a lower house, representatives determined by population, and an upper house, one vote for each state. The representatives to the lower house would be elected by the people. The representative to the upper house would be elected by the state legislature. This was a compromise to the New Jersey and Virginia plans. James Madison first rejected it, but gave in when he found he couldn't get his way. Slavery was the next issue they discussed. Delegates such as James Madison wanted to do away with slavery, even though he himself owned slaves. It was debated whether slaves should be counted in the determining of representatives. Northern representatives were against counting slaves, but Southern representatives threatened to walk out if they didn't get what they wanted. This was a serious threat, since the delegates from New York, except Alexander Hamilton, who had come back from business, had walked out in protest. The compromise they enacted was known as Three-Fifths Compromise. Slaves and Native Americans would be counted as 3/5 of a person. They also determined that the slave trade would stop in 1808. This meant that slaves would stop coming to America in 1808. Slaves could still be owned, though. After this, the convention went more smoothly and the Constitution was read on September 17th, which is now Constitution Day. The Constitution was then sent to the states for approval. James Madison and Alexander Hamilton, along with John Jay, banded together to pass the Constitution. They wrote the Federalist Papers, a set of essays defending the Constitution. These essays helped sway the people and states into passing the Constitution. After passing the Constitution, one of the first cases to come before the newly formed Supreme Court that dealt with the constitutionality of a law was the 1803 case, Marbury versus Madison. This case dealt with John Adams' midnight judges. After the Federalists lost the election in 1800, the Federalist-controlled Congress passed the Judiciary Act of 1801 and the Organic Act for the District of Columbia. This would fill the judiciary of the two counties in the District of Columbia, Alexandria and Washington counties, with Federalists. John Adams would sign the commission and Chief Justice of the Supreme Court, John Marshall, would put the seal of the United States on it. However, John Adams did not finish appointing these judges until late on his last day of office, giving them the name of the Midnight Judges. Only the judges to Alexandria County were delivered by the time Thomas Jefferson took office. He saw the undelivered commissions and reappointed 6 Democrat Republicans and 6 Federalists. William Marbury was one of the judges not appointed. He took the Jefferson administration to court to force them to give the commissions to the appointees. This resulted in Marbury versus Madison. Democratic Republican Party members wanted to abolish the acts that created the judiciary seats. This would allow for future legislation that would be able to let each president fill the Supreme Court. The Repealing Act narrowly passed in the Senate and passed in the House of Representatives with a clear majority. This repealed the Judiciary Act of 1801 and the Organic Act for the District of Columbia. The act also made it so the Supreme Court did not meet for 14 months. Once the case opened after the 14 months, John Marshall, a political opponent of Jefferson and the Chief Justice of the United States, would beat Jefferson on a constitutional point in a way that he could not contend. Chief Justice John Marshall gave 3 questions pertaining to the case. Did Marbury have the right to the commission? If so, did the law provide a solution? If it did a mandamus, an order making the person perform the duty from the U.S. Supreme Court, provide the solution? In court, Marbury was found that he had the right to the commission. The court found for the plaintiff on the second question also. Then the court turned to the third question. John Marshall declared that Section 13 of the Judiciary Act of 1789, which granted the power of mandamus to the court, unconstitutional. The Constitution had not given the power of the mandamus. Congress couldn't grant it either. Marbury didn't get his commission, but John Marshall beat Jefferson on a constitutional point. John Marshall also affirmed the court as an equal branch of government. Even after Marbury versus Madison, the Republicans, which the Democratic Party members were called, even though the party evolved into the Democrat Party, attack on the judiciary continued. The Republican majority House of Representatives voted to impeach Federalist Justice Samuel Chase. In the Senate, it was a different story. Even though the Republicans controlled the Senate, Republican senators were suspicious because the Republicans wanted the seats for themselves. They also hinted that they would take down the justices one at a time. The Republicans failed to get a majority in the Senate, and Justice Chase wasn't impeached. After Marbury versus Madison, the next case that dealt with the Constitution was McCulloch versus Maryland. This case dealt with the constitutionality of the Bank of the United States. The question was if Congress had the power to charter banks. The question first arose when George Washington was president, with Alexander Hamilton, Secretary of the Treasury. He proposed a plan that would pay off the nation's debt. The bill proposed for a bank, which he based on the Bank of England. The bank would be privately owned, but was still responsible to the government. President Washington felt he should sign the bill, but he asked advice. Secretary of State Thomas Jefferson said the Constitution didn't allow Congress to charter a bank. In response to this, Alexander Hamilton wrote a 15,000-word defense. It is considered by scholars to be the most forceful defense that the Constitution ought to be constructed liberally in advancement of the public good, which in essence means that the Constitution implied that the bank could be chartered by Congress. Hamilton would win the argument, and Washington would sign the measure. The Bank of the United States opened in 1791, and its charter expired in 1811. But in 1811, James Madison, an ally of Jefferson, was president, and the Republicans were in control of Congress, so the charter wasn't renewed. Because of this, small banks flooded the nation with worthless currency. During the War of 1812, the Madison administration was forced to renew the charter because the nation needed financial stability. The Bank of the United States was reopened with a 20-year charter. In 1818, the bank started calling in loans, causing panic. This caused states to levy taxes on the banknotes made by the bank. Maryland was one of the states to do this. James McCulloch, a cashier at the Baltimore branch and a thief that stole from the bank using his position, didn't pay the tax, causing the issue to go to court. The issue went all the way up to the Supreme Court. Daniel Webster, a Boston attorney and future senator and secretary of state, would argue the case for the bank. Webster asked 2 questions. Could Congress create the bank? If Congress could, did Maryland have the power to tax it? No one argued the constitutionality of it. Next, Webster argued the states could not tax the bank. After Webster's argument, John Hopkinson, attorney for Maryland, made his argument. Hopkinson said that the bank was really a business used to make money for the stockholders. The decision was in favor of the bank. Chief Justice John Marshall, in his decision, wrote that the federal government was over the governments of the states. From there on, the Bank of the United States would prosper until Andrew Jackson vetoed its recharter. In 1791, the first 10 amendments to the Constitution were added. These amendments are known as the Bill of Rights. These amendments gave the right to religion, speech, press, assembly, redress, to bear arms, of not quartering soldiers, of no unlawful searches or seizures, no double jeopardy, not to witness against yourself, a trial by jury, a speedy trial, a lawyer, that no trial will happen twice, to call witnesses in court, no cruel or unjust punishment, unnamed rights, and unnamed rights going to the states and the people. Amendment 11 would be ratified in 1795. This amendment would make it so businesses, citizens, and foreign citizens could not sue states. Amendment 12 would be ratified in 1804. This revised the election of the president to what we have today. The people would vote for who they wanted to be president. The electors, which are elected by the people and are as many as the number of the senators and representatives combined, would then usually follow the opinion of the people. There have been times when they don't, though. If the election was tied, it would go to the House of Representatives. They would then vote on who would be president. The next major case to come on the Supreme Court docket was concerning the regulation of trade. This case was Gibbons versus Ogden. The Constitution gave Congress the power to regulate commerce with the foreign nations and among the several states and with the Indian tribes. No branches were defined what it meant until 1824. Robert Fulton designed a steamboat that made the trip from New York to Albany in 32 hours. Because of this, the New York State Legislature gave Robert and his partner, Robert Livingston, a monopoly on all state waters. Since the New York-Albany route was so profitable, some Albany businessmen set up a steamboat company without a license. Fulton and Livingston would take the businessmen to court. They would go to a circuit court, which rejected them because all the citizens were New Yorkers. So the trial would happen in the New York State Court. This case would go to the state's highest court, the Court of Errors. The court would rule for the Robert Livingston Company. During the Court of Errors suit, Aaron Ogden operated a wind power ferry from Elizabethtown, New Jersey to New York City. When he converted to steam, it caused a suit that led Ogden to becoming a part of the Livingston-Fulton monopoly. When Livingston died in 1813, Ogden became the defender on the monopoly. When Thomas Gibbons established a rival ferry service, he sued him in court. The suit would make its way up to the Supreme Court. Daniel Webster and William Wirt would make the argument for Gibbons. Webster would argue that since Gibbons had a coasting license, he was able to go on any water of the U.S. He argued that New York had exceeded its authority. Former Representative Thomas J. Oakley would argue on Ogden's behalf. He would argue that it was fully in New York rights to get the monopoly. Others would also argue before the court, but these were the main arguments. Chief Justice John Marshall would declare New York's law void. This would again affirm national supremacy. The court would uphold that decision in future cases. 1787 to 1824 were the beginning years of our Constitution. The document that founded our nation was new and untested, but it was defended time and time again by the Supreme Court, the President, and Congress. Because of all the branches defending the Constitution, this has led to the survival and prosperity of our nation and the Constitution. Over there.